Assalamualaikum warahmatullahi wabarakatuh. First of all, let me introduce myself. My name is Nur Fatimah Balkis, and my group members are Nur Shazani, Nur Inshirah, Nur Maisarah, Nurul Jannah, and Nur Farah Akilah. We are from KBA 2494B group. So, in this video, we will present to you Hibah Takaful critical review from muamalat perspective.
My name is Nur Maisarah binti Syarudin, and I'm going to present the introduction and the conclusion. The introduction. Hibah is the act of voluntarily transferring property ownership from one person to another person while the original owner is still alive, without expecting anything in return or retaliation. It is distinct from a will which is distribute beneficiaries upon death. Hibah also is formed in accordance with Allah's command of giving away one's property in the love of him to one's kinsmen, the orphan, the poor, and the welfare, and to those who ask for help. Participants in Takaful can nominate individuals receive selected Hibah, which will not divide among the deceased person, other legal heirs, upon death. Hibah also permits settlers to disperse a greater amount of their abundance to anybody. And then, Hibah, Umrah and Rukbah, and Absolute Hibah, Absolute assignments, are two types of Hibah in Islamic wealth management. Outright Hibah is a gift given while the settler is still alive, but it has drawbacks like high costs. Conditional Hibah is a contractual Hibah in which the settler imposes conditions on the ownership transfer. Hibah has been included many Islamic financial services offered by some Islamic financial institutions in Malaysia. They are offering in the form of reward, dividend, or consolations. Bank Negara Malaysia has provided a reference on the use of Hibah as a monetary instrument to ensure that Islamic Monetary Foundation use Hibah in accordance with the Sharia law.
Assalamualaikum and hi, my name is Nur Shazani binti Ahmad Yazid. So today I would like to present the main issue that is involved in our topic that we have already choose. The topic that we have choose is Hibah in Takaful. First and foremost, what means Hibah? Hibah means a gift from someone to someone and valid only before that. It means after that, Hibah cannot be used since all the property become inheritance and subjected to faraid. So, what is the issue now? The issue occurs when Hibah in Takaful are played differently compared to the real concept of Hibah, which is Hibah in Takaful are happen after that. We can't deny that almost all the Takaful organizations accepting this product even though it seems doubtful topic in our religion, which is Islam. For information, there are two types of Hibah that we all should know, which is Hibah with condition and Hibah without condition. And for information, Hibah with condition also divided into two parts, which is Hibah Umrah and Hibah Rukbah. In addition, Hibah in Takaful are fall into Hibah Rukbah, which is known as the most controversial Hibah that is stated in our religion. Now, let's get a little knowledge about Hibah Rukbah. Hibah Rukbah can be defined as a gift on condition of the death of one of the party, whether the donor of the grant or the receiver of the grant, as a condition of ownership to one of the life party. As I said before, which most of the Takaful organization use Hibah in Takaful. Do you guys know why they still introduce this product even though most of the jurists are refusing this Hibah? It is because Sharia Security Commission meeting has mandated Hibah Rukbah in the execution of the declaration form grant for transaction involving joint accounts with unit trust funds for account, which is mean Hibah Rukbah has been used in Islamic trust contracts to allow the grantor to reclaim the property entrusted to the grantee if the grantee died. Now let me explain why most of the jurists are refused this type of Hibah. Most of them are refused Hibah Rukbah because they found an involvement of gharar in the akad of Hibah. Why did they say gharar? Because it seems like betting, which is really prohibited in Islam. How can we prove to say it's betting? According to the notion of Hibah Rukbah, if someone wants to receive things granted by the grantor, they must wait until the grantor dies first. It is clearly shows that they use betting in order to get the property, and it is straight away shows that Hibah in Takaful involved in gharar. Most other people are not aware about this issue, so some of the solution must be done in order to settle down this issue.
We present about analysis of the issue. Hibah Rukbah contains element of uncertainty and gharar. Hibah Rukbah is originally permissible. According to the jurist's opinion, they say that Hibah Rukbah is equivalent to Hibah Umrah, but it is different in terms of the condition, which is Hibah Umrah is a form of gift that lasts for the lifetime of a giver or recipient, and the recipient will receive the ownership without being bound by any temporary constraint, while Hibah Rukbah is a grant of property right to the recipient by placing certain conditions. For example, of the condition Rukbah in agreement, if I die before you, this property will belong to you, and if you die before me, this property will belong to me again. The wording of this agreement clearly contains an element of uncertainty and gharar, where the parties involved have to wait until each other's death to receive the gift. The conditions that are placed are clearly against the original concept of the hibah that are permitted by Sharia. According to Islam, the grant property must be owned by recipient, and when the recipient dies, the property is considered to be an inheritance to the next generation as a will. Hibah should not be tied to something that is uncertain and unclear, such as the period of someone's death, so that, in this case, Hibah Rukbah with this condition is invalid. Refers to the Hanafi, Shafi'i and Hanbali Imams' opinion, who emphasize that Hibah cannot be suspended and depends on the future. This renders the Hibah agreement itself null and void due to its uncertain and invalid status. From the analysis, Hibah Rukbah is allowed through the Rukbah contract. However, Rukbah cannot be granted if the conditions of Rukbah are used as the basis of Hibah. The conditions of Rukbah are void and cannot be recognized.
Assalamualaikum warahmatullahi wabarakatuh. My name is Noishira binti Zahimi from class KBA 2494B. Based on the issue regarding hibah in Takaful, I want to give explanation the solution of this issue. The issue, which is after death, cannot be a grant since all property becomes inheritance after death and subject to fara'id. The solution is all contributors in Takaful give money to members that have lost, damage and death. So, Takaful beneficiary are not from Hibah giver, but it is from all contributor of Hibah Takaful. It is because Takaful is a contract made within a group and a protection plan based on relationship between individuals. Thus, the money which gets from Hibah Takaful is from all contributor as a courtesy. Contributor in Takaful is the money payable by the Takaful participant to the company for the Takaful coverage provided under this Takaful certificate, which includes any remuneration for the function and duties assumed by the company in the amounts as stated in the Takaful certificate information page. However, Takaful agents must play an important role because they are not only liable for selling Takaful products, but also offer Takaful services. So, agents must have knowledge of Takaful as the best Islamic solution for financial management. Besides Takaful, agents must accountable to educate the public about the importance of preparing for protection upon their here and main purpose of Takaful products and its benefits. It is made a point of emphasizing that Muslims should secure their well-being of their successors when they pass away.
Assalamualaikum warahmatullahi wabarakatuh. My name is Nofara Akila binti Zulkifli. Today, I would like to share about relate to theories or concept. Hibah is sort of reward, dividend payment or compensation that Islamic financial organisation offer their client to keep them to continue depositing fund into the Islamic bank account. The conditional of Hibah in Takaful has been approved by Sharia Resolution and the Islamic Financial Service Authority, which is IFSA, and it may still run into difficulty in actual use. Next, hibah is not enforceable under the contract of 1950 unless it is written down and recorded. In Takaful, a conditional hibah refers to the Takaful participant designation of an administration or beneficiary during his lifetime to collect the Takaful reward upon his death. Next, the use of hibah in Takaful item results in a problem for which there is no resolution supplied to that purpose. This is because of the nature of the situation. Lastly, the idea of hibah is currently undergoing modification in order to accommodate the requirement of the most recent development in Islamic finance and takaful.
We continue with related theory or concept. The four pillars of hibah takaful are wahib, mahublah, mahub, and sirah. Wahib is the giver, mahublah is the receiver, mahub refers to donated items, and sirah is the pronunciation of the hibah contract. The option to name a beneficiary through conditional hibah, hibah takaful, is a special provision under the Islamic Financial Services Act 2013, APKI 2013. When a person purchases a takaful plan, they have the option to name a nominee who will be entitled to the takaful benefits as wasi or beneficiary based on the hibah in takaful. If a person is 16 years of age or older, they are free to designate any other person, whether or not that person is a family member, to serve as the executor or beneficiary of a hibah in takaful and receive takaful benefits. Hibah takaful rewards are nominated by takaful participants, and wasi is responsible for managing and allocating takaful to other parties. The beneficiary is the person the participant designates as the recipient of the takaful benefit under the conditional hibah based on the percentage indicated in the nomination application. Following the death of takaful participant, takaful benefits will not be included in the distribution of assets or inheritance. Naming is necessary for takaful benefits to be given more quickly without the need for a distribution order, administrative power of attorney, or probate order. Without naming, takaful benefits cannot be released until the successor gets a probate order, power of administration, or distribution order. Additionally, takaful benefits are subject to any apportionment laws that may apply and allow other debtors to make a claim for them. If someone names another person as executor, they must be at least 18 years old and above, and that takaful benefits will be given to the parents of the nominee or eligible claimant or public trustee or named trust business if the beneficiary under the conditional hibah still not reached the age of 18 or is unsound mind to receive it. A witness is necessary for a nomination made by a person of sound mind who is at least 18 years old above and who is not a nominee, either wasi or beneficiary, under a conditional hibah made by the takaful grantor.
In conclusion, hibah is an Islamic practice in which property ownership is transferred without expecting anything in return. It is a financial instrument used by Islamic financial institutions to encourage customers to continue funding their accounts and advance the concept of makasib. Hibah rukbah is a conditional gift that allows the grantor to reclaim property entrusted to the grantee in the event of the grantee's death. Hibah rukbah is invalid due to its uncertain and invalid status, and its implementation requires a contract between the grantor and the grantee, and also hibah rukbah is practiced in Malaysia.
That's all from us. Thank you for watching.